All right. They tell you everything on the internet is true, so everything I'm about to say should be true. Good evening or hello. I'm Jim Bates. I'm an attorney. I have my own law firm, which is called Puget Sound Estate Solutions. And my focus is on estate planning, wills, trusts, estates, and guardianship. And my kind of life focus is on people with disabilities because I have a now 19-year-old stepdaughter with autism. And I like to say that I've learned more about being a good attorney from her than I probably did from law school. But so what we're going to talk, excuse me, what we're going to talk about today is basic estate planning, but kind of set up in a way that we're talking about people with disabilities, because we've talked about guardianships before. We'll talk about able accounts again, but heaven forbid something happens to you, the parent. What is going to happen to your disabled child? And some of what I'm going to say isn't the best news, but there's a lot of good news. But I'm going to start off with an anecdote. This actually really did happen. I was once sitting in my office and the phone rings and somebody said, "There's so and so wants to talk to you about doing a will." I pick up the phone and the woman on the other end says, "I'm 93 years old. Should I start thinking about doing my will?" And once I picked my job off the floor and thought, "You're 93. You should have started thinking about it at about, 40." That kind of made me realize a lot of people don't think about this. And a lot of people also don't think about, well, I need a will because I have minor or disabled children. A lot of people are thinking when I'm in my 60s, I'll do my will because it doesn't matter up until then. And I'm going to tell you, some of the biggest messes I have had have been younger people, because you have minor children. Well, who are those minor children going to live with? You have disabled children. How is that going to be set up? And as we are all worried about, if we have disabled children receiving benefits, an inheritance of basically almost anything is going to knock them off their benefits. So we need to keep all those things in mind. So I'm going to start with slide 3, but let's start with slide 3. So there's 3 or 4 things that we need to talk about when we're talking about estate planning, and they all do different things. The first one is your will versus your trust. And I'll get into that in a little bit more. But basically, those are the documents that are going to pass your assets on to the next generation. So your will say, when I die, so and so gets my stuff. The trust will basically do the same thing, though, with a little asterisk. There's some other trusts that come into play with what we talked about. We talked about some of them last week, but we'll revisit again. And then we have the community property agreement. And this isn't really related to our topic, but it is one of the major pieces of misinformation I see about people in Washington. So we live in a community property state. If you are married, that more than likely means your spouse will inherit your assets, but it doesn't mean there won't need to be court action to make that happen. So just because you are married and you own a house and it's got both your names on it doesn't mean it will automatically pass to the other person. There are some ways to do that. The main one being what's called a community property agreement. If you've been married a long time, you sign one of these. It says, if I die, everything goes to my spouse. That gets recorded when somebody passes away, and it transfers all those assets. The first 2 documents on the top may be the most important that we talk about basically every time I do one of these, which is powers of attorney. And what I call a healthcare power of attorney here, it's a healthcare directive. Some people call it a living will. These are documents that appoint people to make decisions for us if we're not able to. So if I keel over here today, hopefully one of you will call 911. And then I can't make my decisions. I've had a stroke or something. I'm in the hospital. Hopefully I've got a power of attorney, and I do, of somebody who can make healthcare decisions for me, because that is one of the scariest things to have to deal with. Now, if you were here last time, I did talk about our informed consent law. There is a backup that the state created for us, but that's not always the people you want. And I'm a single guy. I am divorced. I do not have I have a child who is disabled, so I do not have anybody who really can make those decisions. I hate to always pick on my mom, but asking my mom to make a healthcare decision would be terrible. So I don't want her to do it. Plus, she lives far away. So I did a power of attorney that says who I want to manage my money and who I want to manage my health care. So let's go to number 4. That's kind of where we are. We're talking about power of attorney. This is a very popular document. It is a very powerful document, and it gives somebody else power to do whatever needs to be done. And the big thing here is this is always a supplemental document. It doesn't take away any of your rights. Now, you may lose some rights because you've had that stroke and you're not able to make decisions, but you can have a power of attorney and the person can be running around, going to casino, taking all your money away. And then you go and look at your bank account online and see that they've done that. And you may then want to revoke your power of attorney. You can do a multitude of different kinds of powers of attorney. People here might have dealt with one. I've signed over a power of attorney because I'm going to Europe for the summer and I want somebody to sell my house. That's a limited power of attorney. You can do a power of attorney for a period of time. You can do a power of attorney that's forever. That's called durable. So what durable means is I sign the power of attorney, and even if I'm incapacitated, I want this person to continue on being the power of attorney. You can set it up to take effect immediately. So I could name Beth Ann as my power of attorney and give her the power right away, or I could require some triggering action, disability, something else. I tend to do most of them disability. When I am disabled and the doctors say I can't make my own decisions, this comes into play. There are a few things you can't do with a power of attorney. I don't think you can change a will or beneficiary designations. There may be attorneys out there that will disagree with me. I used to practice law in Ohio, and I used to get in fights because the law there said you could only change a trust if both the trust and the power of attorney allow you to do that, which makes sense. But people would argue, well, you can create a trust. And I'm like, then how do you have a trust that authorizes the power of attorney? So there are some limits in what you can do. And quite honestly, changing a will, changing a beneficiary, modifying a trust are pretty suspicious things to do when somebody's lost capacity. Now, could there be a reason for it? Of course, there always could be a reason. But it is often something you need to think about. So going to the next slide. Powers of attorney are not as necessary between husband and wife, simply because often the doctors and the financial institutions will allow those parties to act. For financial reasons, the why they're not really important often between husband and wife is because we have joint accounts. So if both people are on the account, the people are on those accounts can access them. You don't need the power of attorney. It is very important if you're disabled or if you have a spouse who's unavailable, or these crazy people who separate and never get divorced. One, don't be them. There's a lot of negative things that can happen there. But if you are legally married and you want somebody other than your spouse to make those decisions, you need a power of attorney. One of the things I always remember, and this dates me a little bit, is there was a news story, I don't know, 10, 15, hey, maybe it's 20 years ago, with a woman named Terry Schiavo, and she was disabled. And the news wanted to make a big deal about, well, her husband's a bad guy and her parents are good people, but he's got the power of attorney. Well, none of that matters, because if she granted, her husband, I don't care if he's, killing dogs in his spare time. If that's who she wanted to make those decisions, she has every right to do that. So it's very important that you make those decisions. And it's very, very, very important if you make those decisions, if you're going to end up in a situation where people want to fight. We don't like to think about that. We never think it's going to happen in our family, but it often does. And one of the biggest messes I see, and this is again a little bit going off topic, but are second marriages or late in life marriages where estate planning's all set up, dude gets married, next thing you know, his new wife's got everything, and that may or may not be what he wanted. There are some people that are out there that probably do want that, but you got to watch what you're doing, because that's a pretty powerful document. I already talked about 770-065, the non-power of attorney informed consent. I talked about that a lot last time. That should be your out. It's not always your out. Now, a couple terms that are important. The principal is the person granting the power of attorney. Attorney fact is the person acting as a fiduciary. And I want to spend a couple seconds about that. A fiduciary is obligated to act in the best interest of the individual. And this can sometimes be hard for people to understand. It is not I'm going to substitute my judgment. It is, you are sitting in my shoes and you act how I would have acted. So, perfect example. I'm going to throw myself under the bus. I'm kind of a cheap guy. I don't spend much money. If all of a sudden my power of attorney decided I'm just going to give $10,000 to all his friends, that's probably a breach of fiduciary duty and not something I would have done. And when you are a power of attorney or a fiduciary, and this is moving to the next slide, it is a very powerful tool because you literally could bankrupt somebody doing this. And I joke all the time, I grant the power of attorney, they go to the casino, they gamble all your money away, you're in big trouble. Another crazy story, I once had somebody call me, and I've used that example every time I do a talk. Somebody calls me up and says, so my daughter took all my money under my power of attorney. Can I get it back? And I said, well, where is it? Did she bank it or did she spend it? No, she spent it all. And then these words come out of her mouth. I never really trusted her anyway. And I'm like, then why did you name her? Like, don't name somebody you don't trust. And I think that also goes with everything we're doing. We need to think about who makes our decisions. And there are two kinds of powers of attorney I routinely do, one for health and one for finance. And those don't necessarily need to be the same people. In my own family situation, I am my mom's financial power of attorney. I'm the lawyer. I know about money. My brother, the drug dealer, okay, pharmacist, whatever. He is the healthcare power of attorney. One, because he lives closer, and two, because he understands the medical stuff. And I think I joked last time, anytime I hear doctors talking, it sounds like Charlie Brown voice to me. It's wah, 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 wah. So if you are a fiduciary, that is a very high standard. As I said, it's not how you think they should act, it's how they would act. They must not harm the beneficiary and absolutely, absolutely must not use the money for their own benefit. Now, how does this come into deal with our special needs kiddos? Well, you may want some gifting power in your power of attorney. And it may be you want to gift money to your special needs children because that isn't out. If you go into a nursing home and you go on Medicaid, you can actually gift all your money to your special needs disabled child. Now, is that a good idea? I'm going to give you the legal answer. It depends on the circumstances, but that isn't out. And I've had a few people who were legally disabled, but their benefits were pretty minor, that we said, yeah, let's just gift all the money away. It's not really affecting them. We have other people, and I've noticed this especially with people on certain drugs, that the cost of those drugs, if they're not on Apple Health, is tens of thousands of dollars a pill or something. That person does not want to gift their money to their disabled child and have that child lose the benefits. One other thing the fiduciary always has to keep in mind is you can have a court order in accounting, so know what you've done and know what the appropriate where all the money went, because the courts are not going to let you get by. Switching to the next slide, we'll talk about healthcare directives. I tend to call these healthcare powers of attorney. That's what the law says. They do a couple things. Sometimes people call them the living will. They allow you to refuse CPR, food and water, all those things, or require you to be on it if that's your wish. I'll admit mine says that if I'm terminal or permanently unconscious, which my understanding is your brain is turned to jello and not growing back. You can see I'm not a doctor. I don't want to be plugged into machines. Other people may be there. You can add other requests. I have had some Jehovah's Witness clients who have some issues with transfusions of blood, and they put that in there. There's also some death with dignity stuff that I'm not going to go deep into, but you can put some of that in there. I in my own family, my mom lives in Arizona, and she's if I ever end up in a nursing home, I'm moving to Washington so I can have the assisted suicide, because we don't have that in Arizona, which I'm not sure if that's true or not true. But there's some states it's allowed, some states it's not. The other thing that can be in here is if you have any care, you have your own, I don't want to say weird because we all get to choose what we want, but you have your own things that you want done, you can put them in there. And I think that's a really good idea if you have those wishes. I have seen some people who have put in one I never thought of, was antibiotics. If I get really sick and I get infection, do I want antibiotics? And then we learned all about ventilators during COVID. Do you want a ventilator or not? Because some people may choose not to. So that would all go in your document of what you want to have happen if you get sick. Going to the next slide, there is another document out there called a physician's order for life-sustaining treatment, or the POLST form. I highly recommend this, but I'm a lawyer, not a doctor. This is something you do with your doctor. And this is if you want CPR, if you want this, if you want that kind of stuff, more high-end stuff that they don't let us attorneys kind of talk about. But I think that's a great document. And I have certainly seen facilities and kind of assisted living or even independent senior living where everybody's got them on their fridge. That's not a bad idea, because if the ambulance comes, they can just look, it's up there. All right, we're good. I have been told that even if you say you don't want CPR, the emergency crews may still do it, and they'll sort it all out when they get to the hospital, but it just depends on your circumstances. So that's healthcare and financial power of attorneys. Great tools. Maybe the most important thing you can sign during your lifetime, and often something people aren't really thinking about. The other nice thing to tie this all together, and this is for our people with disabilities, is if you can do a power of attorney, you might very well avoid a guardianship. And I talked a lot about guardianships last time, but they are expensive. The court is involved. And if you have a child who has some level of capacity, even if it's picture communication, pointing, you might be able to do a power of attorney and save all the stress you're worried about. The irony of all of this, which cracks me up across the board, is I walk into a bank with a court order of guardianship. They sometimes give me kind of side eye, like, what are you trying to do here? I walk in with a power of attorney, they never give me a hard time. It should be the exact opposite, but nonetheless. But power of attorneys are really useful tools and something we should all have. And if you have an 18-year-old who is or older who is disabled, my first question in the guardianship discussion is, can they do a DPOA? And I met somebody yesterday we're doing a guardianship for, and I had gone to meet the child, and he is nonverbal and even pointing, and he really was non-responsive, so he can't tell me who he wants to make decisions. But a lot of our kids can say, if you were sick, who would help you, mommy or daddy? And I think that's enough to have some legal capacity to understand that. So very, very, very useful tool, and something everybody should have. So now we're getting to the bad part of the program. Next slide. We're now going to talk about death and dying. And as I joke all the time, I do death, dying, and disability. I'm not real fun at parties, but I'm going to bring the mood down, and we're going to talk what happens when you die. And the first term I'm going to give you is, what is your estate? So people get confused, even sometimes practitioners get confused about different kinds of estate. Just your estate is everything you own. It's your real property, your personal property, your IRAs, your retirement accounts, your life insurance. There's a concept called rights of appointment. Most of us don't have to deal with those, but that is something
You want a little half a cup or something?
Coffee. Okay. So I thought somebody was asking a question. This is everything you own. And these assets all may get transferred differently, and we may have different things for all these assets, but it's all part of your estate. The scary part of your estate is the taxable estate. And I think I'll talk about that later. If I don't, I'll put that in here. But we do have some estate taxes we have to worry about if we're very high net worth. We have a Washington taxable estate. We have a federal taxable estate. We have what's called a probate estate, which is the things that go through probate. And you just have your estate, which is all the stuff you own. So we'll start there. I'm going to get fired for the next slide because it is 2024, not 2023, and I missed this one. We are now up to $18,000 that you can gift per year. So this is an interesting concept, and it is something that I get questioned about a lot. So the IRS, and again, I said the IRS allows you to gift up to $18,000 per person per year. So if you are married, both you and your spouse can gift $18,000 to each of your kids, no problem. You can also walk down your street and hand $18,000 to everybody on the street. I don't recommend that, but that would be legal. You can gift to anyone. and there is no limit on the amount of gifts under $18,000 that you give. Now, one thing I tell people to watch is where the money is coming from that you're gifting. Because if you gift IRA money, if you gift stock, there could be capital gains, there could be income tax. But for simplicity, I'm just going to talk about cash. You got money in the bank, you can gift that to anybody you want. If it's 18,000 or under, you do not pay any tax. The receiver does not pay any tax. So why are people concerned about gift tax? Well, because it could happen. So if you gift more than $18,000 and it is not for an acceptable exemption, and those include educational expenses paid to the university and medical expenses paid to the facility. So if you're giving your child, I don't even know what college costs anymore, but if anyone of you told me, it'd probably freak me out. You're giving your child $50,000 a year to pay for college, you've got a little bit of a problem. So we're going to go into a completely fictional world where I have a child going to college. If I gave that child $50,000, the first thing we do is we subtract $18,000 from that, and that is not taxable, not a concern. That's your exemption. So the money over that, and it's too late on a Thursday night for me to do math, but around $30-some thousand, is a taxable gift. You have to file what's called a gift tax return with the IRS, and then do you have to pay tax? Well, again, it depends. It depends on how much money you have. So right now, and again, I'm operating in 2023 because that's the numbers on the slide. Right now, if you die with less than $13 million, that gift tax return doesn't matter. So I talked about, I think I talked about this last time, but I'll repeat it because it's a good story. Client comes into the office, says, I've just been given 4 months to live. I'm not, it's May. I'm not going to survive through the year. I have a $3 million estate. How can I avoid paying estate tax in Washington? Because just for some education, estate tax in Washington is $2 million. So I said to this gentleman, I said, well, you've got $3 million. What does it consist of? And he's like, well, I've got a house worth about $1 million and quite honestly, $2 million in the bank. And I'm like, well, that makes it easy. We can give $500,000 to each of your kids. That will knock you under the $2 million and avoid your estate tax. You know you're going to die this year, so we know that you will not exceed the $13 million, and we're good to go. So there's a lot of moving pieces there. The problem that we're in is in 2026, this is all potentially going to change. We have a law that was set up whenever it was set up, probably about 10 years ago is my guess, and it will sunset, and we don't know what the rules are going to be in 2026. Last time this happened, we found out what the rules for that year were going to be about August, but it's going to be a little bit of a problem. What it will probably do is sunset back to whatever the rules were 10 years ago, and anything before COVID feels like it's been kind of ripped from my mind. So I'm not even remembering what those rules were, but it'll be much less than $13 million. My fear is that the federal estate tax will go from 13 to somewhere in the 2 to 5 range. I don't have many clients with $13 million, but I got a lot of people 2, 3, 4 million, and I hope they're not going to be paying estate tax. But it could happen. Now, before we move on, and this is a little outside of our arena, but I want to bring up something that gets asked of me a lot. Well, you just told me, Jim, that if I give away money to qualify for Medicaid, they have a look back period. And the answer is absolutely yes, they do. But I can give away $18,000. And I'm like, well, that's an IRS rule. Medicaid has their own separate rules. So the IRS says you can give away $18,000 and pay no tax. But Medicaid in Washington says you can give about $400 away, and that's going to anything over that's going to cause a penalty. So one of the things I try to educate people about is one law doesn't control everything. There's always little pieces. And sometimes if I should do this for the presentation, you could draw, I think it's a Venn diagram with the intersecting circles. That is often what happens. You've got probate law, you've got tax law. In our case, we've got disability law, and you've got the Medicaid. They're all interrelated, and there's all pieces they touch, but they can all be very different. So always get good advice from somebody who knows what they're doing if you're looking at giving money away. Don't just give money away willy-nilly, because it can come back to bite you. All right. The second way you can pass your estate after death is what's called contractual or beneficiary arrangements. We're all pretty familiar with these. These include our life insurance. So if you have life insurance, generally a beneficiary is named. If you have an IRA or 401k, generally you've got a beneficiary on there. Now, I'll give you a tip. You probably don't want to put your special needs child on there because if they inherit your 401k, they probably just lost every benefit they've given. But I'll give you a workaround on down the line. If you decide, hey, I don't want to, I've got enough money here that my IRA is a portion of my estate, but I'd rather leave my house and some cash to the special needs kid. Well, my other kids get the IRAs. That is another way to do it. You could say, okay, my two kids split the IRA. That's $2 million. My cash in my house, which is about $1 million, goes to the special needs kid. That is one way to look at it. That's not a plan for everybody, but it's something that can sometimes work. The other thing I like this kind of contractual thing for is if you've got somebody you want to leave a little something to, but you don't really want them involved in your will, you can name, I'm put my three kids in my will, but I've got this other person who, maybe a nephew, I want to leave 10 grand to. We'll go open a joint and survivorship account or a TOD account. We'll get to those in a second. Put 10,000 in there, and then that can go to that person. Employee benefits like stock option can also have contractual stuff, and it's also not unusual to see it in kind of buy-sell agreements. We've talked a little bit about community property. I'm going to go to the next slide. We apparently have 9 community property states, but it does not convert property automatically to the spouse. They're going to inherit it, but it would still need to go through probate. That's what the community property agreement is for. And if it's a long-term marriage, I like community property agreements. If you got married last week, I'm not jumping up and down to do one for you because we don't know where things are going to go. Because everybody knows their marriage is forever until it isn't. And that's kind of, I'm a cynic about all this kind of stuff just because I've seen everything. So let's go to the next slide. What is community property? It's basically everything you acquired during the marriage, except property and debts brought into the marriage, inheritance, gifts, and personal injury settlement. But you will see changing title and commingling may affect the character. This is what people do wrong all the time. So you inherit some money from your parent who's passed away. It's your money. It is separate property. It's not community. But your spouse says, hey, I'm really uncomfortable. My name's not on that account. Or we need to put that in our joint account. That now may make it community property. So I tell people it's sometimes hard within their relationship, but if you inherit a lot of money from your parents, keep it separate. That is your money. That is not, your spouse's money. And it's sometimes saddening to me where I've seen people kind of force the other person to put the stuff into a joint name and then file for divorce. It's really depressing. We've talked a little bit about the next slide, which is 14, which is community property agreements. What the goal of that is to avoid probate. It is only for married couples or registered domestic partners. It will convert your separate property to community property. It could be immediate or at death, and it may include future property. So what you can do is you can draft one that does anything. Most of mine are set up that the property stays a certain way, but it gets transferred at death to the survivor. As I said, I really like these for people who have been married a long time. For the people, who've had 6 marriages and they're on their 7th and they've been married a week, probably not the best idea. This also becomes a problem, and there's a nice picture there of an older couple. We're assuming they've been married for 100 years and they met in high school, but that could be the couple that met at the senior center last week, and now they're doing a community property agreement, and both their kids are getting nothing. It's always going to the other spouse, and that's always scary and can be a hard thing to do. Next slide talks about community property advantages. The big one is it's inexpensive, it's easy, and it avoids probate. What are the disadvantages? Well, it can really screw up how your assets are set up. One thing that is also a disadvantage is it's pretty unique. You can go back to that slide. That was good, to number 16. The one big disadvantage is they're not good nationwide. So if you're living in Washington, you do one, and you go to Ohio, it could be a real problem. It can mess around with your Medicaid. It can mess around with your tax planning. And it is a bilateral agreement. So if you and your spouse agree to something and then disagree, it can be really, really hard to change it if your spouse is saying, nope, I don't want to sign off. You're now stuck that way. Um, there's also some problems, and I would say this isn't just community property agreements. There are problems with some pre-printed forms floating around. I know a lot of people like to get documents off the internet. They sometimes really scare me. Sometimes they're good, but sometimes they're really scary. What I tell people is if you are looking to do this stuff using estate planning off the internet, try to find something Washington related, because all our states are a little bit different and we all have different rules. Um, I'll talk about probate a little bit later, but one of our big differences in Washington is we have what's called non-intervention probate, which is basically easy probate. That is not something that exists in the majority of states. So it is something you don't want to do, and that may not be appropriate if there are children from prior marriages. I have seen so many estate plans where the parents have set everything up. They don't really think about it. They put everything joint. They do a CPA. All the money goes to the surviving spouse. The first person who died, their kids are cut out completely, and now everything is going to the children of the party who survived. So I'm very leery of that, and that can be really hard, because what happens if the person, well, let's pick on me. I get married, make a bad choice. Not going to happen, but well, with my track record, it could. And I have my estate planning set up that everything goes to my special needs stepdaughter. I could leave everything to my new wife, and my special needs stepdaughter gets nothing. And that's why you need to be really thoughtful about how you set this stuff up. And you also need to look at it holistically, not kind of one thing at a time. So we're going to switch to titling of assets. You can do something in trust for. You can create a trust. The in trust for scares me a little bit, because that can cause some problems. In fact, I have a friend who passed away that he was, there was a deed. It's all it was. It was a deed where he was holding the property in trust for two people. And without some pretty expensive lawsuits, I'm not really sure how I figure this one out. Quite simply because there's no real controls. Now, if you do a more standard revocable living trust or something like that, usually it's in there. Usually it says what's going to happen, but we all need to worry about that. A big one I see a problem is with a special needs trust, which is I'll get into this later, a third party special needs trust that never says who gets the money if the disabled person passes away. That's pretty common, and it may not matter because the special needs person may not use it all. But if it's there and you want it to go to your other kids, there's no reason, if somebody, if the special needs person dies unexpectedly, that you don't want it to go back to your own kids. So you got to be really thoughtful of how this all works. There are two very useful designations called payable on death and transfer on death, but they can get you into trouble. What they're great for is if you have a bank account and you want to leave it to one person, they're wonderful. So the typical little old lady who has the daughter who lives with her, POD and TOD are great tools, because you just leave everything to the daughter. She gets it all, avoids probate. It's easy. You can do TOD deeds. They have some really, really weird requirements about them. If you and if I was to sign a quitclaim deed of Mariners Stadium to Nate or Jeanette or somebody on this line, you can sign a quitclaim deed that doesn't mean anything. It also has to be recorded to prevent any third parties. Well, with a TOD deed, to be valid, it has to be recorded. So if I'm somebody who's meeting with somebody disabled, say tomorrow night to sign the TOD deed, I'm sweating the whole weekend that they don't die, because if I'm not at the county recorders Monday morning getting it recorded before they pass, that deed is no good. So be aware of that. Now, joint tenancy, and I've jumped a little ahead. The next slide's actually on TOD deeds. There apparently are about 29 or 30 states. They're useful. They're really useful if you've got out-of-state property and you don't want to do your probate in another state. That's a real problem. Now, joint tenancy, which is the next slide, there's a couple of those. Joint tenancy is really who owns the property. So most of us in Washington, much to my chagrin and confusion, own our houses joint tenants, which means 50-50. You own an undivided 1/2 interest with your spouse. That doesn't mean it goes to your spouse. It doesn't mean your spouse inherits it, and it absolutely does not mean that your spouse gets it avoiding probate. You can do a deed that does that. It's called joint with rights to survivorship, JTWOS. And much to my chagrin, as somebody who came to Washington after practicing somewhere else, these are not common. I would say when I was practicing in Ohio, almost everybody who's married to bought a house had a JTWOS house. That is not the case here. In fact, it's kind of an outlier when I see it. Now, joint tenancy can be a problem, and I've listed a lot of problems there. There are hazards of assigning children as joint tenants. I got a story for that. It can be a loss of control. I have a terrible story for that. There can be some issues with step up and tax credits, and I'm not going to get into deep tax planning because nobody wants that on a Thursday night. But what my concern is a little bit loss of control. And this is a real life story. I'm not making this up. Parents decided that they would add their child to the property JTWOS. So all three of them own it, which means when the last parent dies, child inherits all the property. Well, that's well and good for estate planning purposes. But the problem was the child was a drinker and went out one night and crashed his car and ended up in a DUI and got sued. And now lawsuits are coming to partition the property, to sell the property, mom and dad's house, because the son was a 1/3 owner. This is why you don't add your kids to your deeds. There's some other step up tax reasons you don't do it, but that's one of the main reasons you don't do it. The worst thing I ever saw, and I still can't believe this happened, daughter convinces parents to sign the house over to her because we want to start that 5-year clock running for Medicaid, and they do it. And then daughter evicts them. Oh. And I am literally in shock anybody would do that to their parent, but that's flat out what happened. So don't do that. Don't add people to your deed unless you 100% trust them. And I'm not sure I 100% trust anybody. So next slide. Another way you can own property is tenants in common. I'm not going to spend a whole lot about this one. This is not the greatest way to hold property because each individual can sell their interest at will. And it's not really a good way to own property. So I'm not going to go to that one. We've already talked about the next slide, which is the wonderful JTWOS. One thing I did not mention is this could skew your estate plan. And this is something that I want to talk about. I've said a couple times, you need to look at this not in the narrow focus, but in the more overall focus. What I see happen a lot is, and to make this simple, I'm going to be talking about somebody with 2 children. Parents have a will that says, when I die, everything goes 50-50. But they go to the bank and they put the daughter who lives down the street on all the bank accounts. And unfortunately, one of those all the bank accounts is the bank account with $1 million in it. When parents die, it doesn't matter that will says 50-50. The person on the bank account gets the house. And I was saying beforehand, one of the kind of worst planning techniques I've seen for disabled individuals is the parents leave everything to the typically developing child and say, oh, they'll share it, they'll take care of it. Well, they might, but there's no legal requirement they need to do that. They could say, hey, I got all the money. I don't want to deal with my sister anymore. I'm out of here. And they have every legal right to do that. And the disabled party has no recourse. So it's very important when you set up your estate plan, you look that everything matches the way you want it to be. Another thing that, and this is your free advice for the night, go and look and make sure you don't have ex-girlfriends, boyfriends, spouses on your beneficiaries. I have run into a couple cases recently where back in the 70s, and it's always the guys are always the one. Guy puts a girlfriend on the property, never takes her off, dies. We're now, 50 years later, they haven't dated since, 1973. And that party is now getting a portion of the property because they were added to that property and never taken off. So don't add people to your property. And if you do, when you break up, get them off. which can be hard sometimes because they're going to want money. And I think what a lot of people were doing here is property wasn't worth all that much, and values have just gone up, 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 up off the roof. And here we are now. And now you've got somebody who wants to be bought out. And I had a very angry family because dad put an old girlfriend that nobody liked and had been out of the picture. And she, maybe not, it's hard to say what's the ethical choice here, but she legally wanted her half of the property, which she had every right to do. So you've got to watch how things do. Don't always do what the simplest thing is. And let's move to slide 22. What are the problems of assigning joint tenants? Well, we've talked about this. We could lose our step up in basis. We could have liability claims. Hey, your kid gets in trouble with the IRS and the IRS comes after you. Becoming divorced could be an issue. It shouldn't be an issue because it should be separate property, but we've all heard stories about divorce. My story about divorce is a really interesting one. I'm sitting in my office one day and I have a very disagreeable attorney calling me up saying, I'm sending you a subpoena. Your clients need to provide their financials. And I'm like, for what? What are they involved in? And he's like, well, their son and daughter-in-law are getting divorced, and I represent the daughter-in-law, and I want my client's share of their property. And I'm like, one, step off. They're still alive. You get nothing. Two, you can get a subpoena from the court. I'll honor that until then. Get lost, because you have no right. Well, they're going to inherit the money anyway. Well, that's not the way the law works. And then I advise my clients to go spend all their money. So divorces can be a problem. Businesses can be a problem. The IRS can be a problem. And creditors have somewhat limited rights in what they can step into and what they can take. But the IRS is kind of the super creditor. So going to the next slide, I'm going to tell you a little bit about intestate. That is dying without a will. And the state has written your will. It goes to your spouse, then your children, then your parents, then your brothers and sisters. And that's just a big mess. And if you've got disabled kids, it's a bigger mess because they're going to need a guardian ad litem. And that's going to increase the cost. So do not, if you take anything away from today, do some sort of will. And I was just bad mouthing wills on the internet. It's better than nothing. And we don't always live, our lives are not, what's the I'm trying to think of an old TV show where everybody's married, everybody's been married 100 years. It's not the Andy Griffith Show, and people have complicated lives. And as I've said a couple times, I consider my stepdaughter my daughter. I was there since she was 2 years old. She's been in my life ever since. She's going to be calling and really angry that I'm not picking up the phone because we talk every night on Zoom because I'm talking to you guys instead. I will make up for that tomorrow. But we don't always have, our families are not what the law sees. I see a lot of people who come in and say, well, I've got 3 children. And I'm like, that's interesting. Why do they have a different name? Well, they're not really my child, but I think of them my child. I'm like, oh, that makes a big difference because that's not somebody who's going to inherit under the law. So we need to put them in the will. And you often see wills that say to my children. Well, that's going to be to your biological or adopted children, not to the other person you think of as a child that everybody in the family thinks of a child who you inherited. Or we have grandparents raising grandkids. We just have a lot of different situations depending on what community we're in. I've got a guardianship I did for a very disabled young man that one of his parents is deceased. One of his parents is just drug, living on the street, and grandma's taking care of him and doing a great job. But when we had to get guardianship, it was a little bit hard because we had to, we had to explain to the court, we've got somebody who's floating around out there who has rights, but we don't know where we are. So this is one place I tend not to put pictures in my presentations, but thumbs down, you don't want to die without a will. I was thinking there've been a couple celebrities who've died without wills, and that blows me away with the kind of money they have. They don't have wills. There's a lot of celebrity stories I can tell you, but I'm not really going to. Okay, let's move to the next one. This is kind of just a chart of should I make a will or not. This is kind of just a little will. Let's just skip over that one and go to the next one. So a will. You are now dying testate. You have a will. You get to control where the money goes. You get to give money to charity. You get to create trust. You get to nominate your executor. You get to nominate a guardian. You get to nominate your distribution. So if you said, my child is a good person but struggles with some substance abuse, you could create a trust in there that allows the trustee to say, well, they're on the drugs, we're not going to give them any money, but when they clean up, they can get off them. I once did a hugely complicated trust for a very wealthy gentleman that I think we both knew his son was never cleaning up, but we gave him the opportunity to do that. When I say you nominate guardian, some of the biggest mess I see that people don't think about is you pass away with minors. Where are those minors going to go? Are they going to go out on the street? What are they going to do? You've got to provide for that. I have, and this is going to sound really silly, but I have some provisions in my will to provide for my dog because I don't want my dog going on the street. My dog is just going back to the rescue they came from, and they get a little bit of money, but there are a lot of different options, and we all have different things that we want to do with our money. Okay, let's talk about the next slide, which is probate. And I'm going to start by saying probate needs to hire a better brand manager, because probate, if you listen to the TV and the radio, it is apparently like the devil is the worst thing in the world and probate's right behind. That's not always true, but because probate is kind of a state thing, it can be. And in certain states, it's a lot more work. So I talked about, I practiced in Ohio. The law I practiced in Ohio with probate got changed about the time I left. And because it was taking a long time, at the time, it had to stay open for a year. And I think that's gone. I think they changed the law that it now has to be closed within 6 months. Generally, what happens with probate, it's a state law. It's pretty simple and reasonably inexpensive in Washington. We might all have different opinions of how inexpensive it is. It can be complex and other expenses in other states. I'm looking at you, California. Property is sort of tied up and sort of not tied up. People like to talk about, oh, it was in probate for forever. That is usually one of three problems. Beneficiaries are fighting, the PR is not doing the job, or the attorney's not doing their job. Generally, in my experience, a pretty straightforward probate should take 6 to 8 months. What happens in probate and the way this all works is this is kind of created to make sure your bills get paid. So what happens is that you have a creditor window that is 2 years, but you can cut that down to 4 months. So that's kind of the controlling thing. I completely against distributing money until that creditor window rolls around, because if you say mom and dad didn't have any debts, it's fine, and then you distribute the money, and then a debt comes in, if you're the personal representative, you're on the hook to pay that debts, and of course your siblings aren't going to pay you back. So you've got to watch that one. The personal representative may be paid. A lot of my personal representatives do not take a payment. I just finalized a probate in the last couple of days that was completely ridiculous, because the woman who died had been appointed executor for her father in 1993 when I was in college. And we had to go reopen that with my personal representative, who's about my age. I can't remember if she's a few years younger, a few years older. She was talking about, she must be a little bit younger. She was like, 18 when this probate was open. And we got to go clean it up because it never got finished by the woman who was appointed. Okay, next slide. When is probate required in Washington? When you have over $100,000 of assets or real property of any value. So I don't know if there is any property in Washington anymore with no value, but if you own, the square of land that's the tip of Mount Rainier, it's probably not worth a whole lot. But even if it's worth $5, that has to go through probate. If you have a bank account, it has to be $100,000 or over. If it is under $100,000, you can do what's called a small estate affidavit. And I'm not going to bore you with the code number because it's on the slide. It's an affidavit. It's called a small estate affidavit. And you wait 40 days after death. You say that here's what the will says. Here's who the heirs are. And you can transfer assets. And that's a very powerful tool. So let's switch tracks again and go to the next slide. So why don't we make wills? This is something I ask myself all the time. A lot of people think it's too expensive, or they have too little property, or they don't want to deal with legal stuff, or they can't predict the future. But quite honestly, I'm going to be honest, most of us don't do it because we're just procrastinating or too busy. And I know a lot of you who have disabled children, dealing with your life, dealing with your children, adding in the other children you might have, that fills up probably more than 24 hours every day. My last one on here is my favorite one, the people who don't plan to die. I once had a client came in and we did the estate planning, and as we're signing everything, she's telling me, don't say that happens when I die. And I'm like, but that's what happens when you die. And she's like, I'm not going to die. And I'm like, oh, you got to tell me how you work that deal out, because that's not one I've heard. But we all want to procrastinate. It's not going to happen to us. I still kind of live in shock that I'm turning 52 this month. Like, I'm like, how am I so old? I still feel like it's 1998, not maybe 30. And I think we all just want to put it off. And as I keep telling people, the people who don't plan, they get the thumbs down, and they have the biggest messes to deal with. No question whatsoever. So do not take the ostrich approach to estate planning, which is to stick your head in the ground and not do anything. Okay, next slide. We're circling back to trusts. Trusts are probably the most oversold thing in the estate planning world, because they cost a lot of money and they make money for attorneys. You hear a lot of people say everybody should have a trust. Again, it depends. If you come to me and say, hey, I've got property in California, Idaho, Washington, Oregon, I'm probably going to say you might need a trust. If you come to me and say, I have a special needs child, there's going to be a certain kind of trust. Are we going to do a revocable living trust? I don't know. We'll find out as we go. A trust can be standalone. It can be in your will. It doesn't make any difference one way or another. There are absolutely tax implications of you doing a trust. But the big thing with a trust that's really, 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 really important is it is not worth the paper it's written on unless it is funded. What does that mean? You need to retitle your assets in the name of the trust. So what I see a lot is I see people come in, and I don't have one here. I had one earlier in the week with these beautiful binders with all this paper in them, and it looks all impressive. And then I go online and look up, well, the house is still in their name. And I say, how are your bank accounts? Well, they're all in our name. I'm like, you do realize you're going to probate everything now because you never funded the trust. The other problem I run into is people who own a house. We put the house into the trust. They move. They never call me. They never tell me they have a different address, and somehow it's my fault that their house isn't in the trust. So a trust does take a lot more work upkeep. It's a lot more expensive. Now, for some of us, it is also mandatory, because if we have the disabled child with benefits, we absolutely need to be thinking about trusts. Trusts can be revocable, which is you can change it, or irrevocable, which you can't change it. I'm not going to get into irrevocable trusts. It is something you want to think there. You want a lot of good advice before you go down the irrevocable road, because that's you giving up your right to your property. Okay, all trusts on the next slide have three elements. They are a separate legal entity. They have a grantor, settlor, or trustor. They have a trustee, and they have a beneficiary. The grantor, settlor, trustor is the creator. The trustee is the manager, and the beneficiaries are the people who get the money. Often, you could be all three of those for a period of time. If you do a revocable living trust, you might very well be those for a while. You will always be the grantor, settlor, trustor. You will probably not always be the trustee or the beneficiary. Okay, let's talk about types of trusts. And this is where I get on my soapbox again. I'm going to talk about these. There are probably other ones out there. There are some very pretty names that people come up with, but there's no real statutory creation of these names. You hear revocable living trust. You sometimes get people confusing that with will. That's the trust most people have. It's a probate avoidance tool. Special needs trust is both a thing and not a thing. We talk about it like it is a thing, but there are a couple different kinds, and we're going to talk about those. And for what we're doing today, that's one of the most important pieces, because those trusts have different requirements and they're used for different tools. An exemption trust, credit shelter trust, bypass trust is for people who have over $2 million. And now I'll talk about estate taxes. So We do have an estate tax in Washington. It starts at $2 million. It's actually 2.2 million for most people, a little bit more in certain circumstances, depending upon what you have. So if you have over $2 million, you may have to pay estate tax to the state of Washington. We also have a federal estate tax, but it is $13 million right now. Right now, we also do not need an exemption or bypass trust for the federal estate tax, but it is still required for Washington. So I do a lot of those because I have a lot of people that are in the $2 to $4 million range. And to show an example of a will, I've done wills with 3 trusts inside. The first one is the credit shelter exemption trust. So when the first person dies, we can protect their taxes. Then we have a special needs trust for the disabled beneficiary. And we may have a minor trust, which I put in all my wills, in case somebody under 21 or 25 gets the property, that we can hold it until they get a certain age. And people often say, but my kids are older. They're in their 30s. I don't need that. And I say, grandkids? What happens if your child dies and it goes to your grandkids? Oh, yeah, they're 3 years old. We don't want 3-year-olds to get a whole lot of money. It's a really bad idea. Okay, so let's talk about the next slide, which is special needs trust, which is the most important part here. Most commonly, I think they're in a will. I am playing around with how I do them. I put them in the will, but I've started adding kind of like an exhibit to the will that you just rip off because banks can be funny. One of the banes of my existence is trying to figure out where banks get their legal advice from. You can do a standalone trust. Now, I will be very honest. I did a standalone trust for my daughter for the very simple reason I'm an attorney and it cost me nothing. For most of my clients, I do not do them. I put them in their wills, but it can be either way. If you do a standalone trust and it's created today, it must be funded. And in my case, all I put into it is I taped 20 to the back page of the trust. So, sorry, excuse me. So now it's got $20 in the trust. If you put piece of property in there, that can also be funding, but it needs to have something in there. That is actually not the law in a lot of states. Now, I just want to talk a little bit about the different kinds of trusts. So, and I think I'm just looking here if it's got this as a slide or if I don't have this as a slide. So we're going to talk about managing special needs trusts in a second, but what I want to tell people is that there are different kinds of special needs trusts. And there's 2 or 3 major kinds. There is what's called a statutory special needs trust, which I tend to refer to as a D4A trust. That is the United States code that authorizes this trust. There is a somewhat related one, a D4C, which is a pooled trust. No, it's not a trust for your swimming pool. It's basically a special needs trust where they pool all the money for a whole bunch of beneficiaries in one trust. What a D4A or a D4C is a statutory created special needs trust, which is created by statute, by law, that is for the assets of the individual. So where this comes into play is typically developing gentleman is riding his motorcycle. He's not wearing a helmet. He crashes his motorcycle. He now has a traumatic brain injury. He may have money. He may get insurance from the settlement that will knock him off his benefits. He would then do the D4A trust. Why this is a big deal is the D4A trust has a payback provision that anything left in it when that party dies goes back to the state. So we don't really want to use those for our kiddos. We want to use a different kind of special needs trust, which I call a third-party special needs trust that doesn't have that payback provision. And why is it different? Because it does not have the money of the individual. It has my money or your money. We are leaving it to our children, so it should not have to pay back to the state. I was in a guardianship hearing a couple weeks ago, and it's kind of a contested guardianship situation, and I'm not going to get into any of the facts with that. But what happened was one of the people who is a guardian thinks they are the sole guardian, thinks they get to do whatever they want, and they move the individual into a facility. I'm not sure if that was the individual's want or not. That's a separate question. But they had inherited some money, including a condo, that were in a special needs trust. And what this woman says during the court hearing is, well, I'm going to spend all that money on him and then he's going to go back on Medicaid. And both I and the court visitor, which is an independent third party attorney, immediately went on the Zoom and said that's not an okay choice, because what's happening there is she's spending money on his care that she wouldn't need to, that could be used for other things, because that is a third party special needs trust. So here's an example of somebody who's in a fiduciary position who doesn't understand what they're doing. The other thing about managing a special needs trust is keep your records, keep your funds separate, only use the money for the benefit of the beneficiary, and don't give things to the beneficiary that you don't want to see them squandered. So if you say, hey, I don't mind if you spend 20 bucks on candy, here's 20 bucks, but don't give them $1,000. Don't give them a gift card with, 500 bucks on it, because they're going to spend that money and they may or may not do the right thing with it. I had a really difficult guardianship, and this is a long time ago under the old law, and I'm no longer involved in this one, and I hope they have actually got rid of it, where the gentleman was buying all kinds of stuff on the internet. So he was given a debit card, which I don't think he should have been. And he was buying things on the internet, and he was spending crazy amounts of money. Some of it was candy. Some of it, I think, was more nefarious internet things. And it was really hard when we got around to do the accounting, because we couldn't account for what he spent. And quite honestly, I think that was a problem of the guardian not properly managing the money. Same thing if it's in a special needs trust. You're a fiduciary, you're managing this money for the person. Your butt is in the hot seat if you screw up. Even if you don't screw up and things happen, your butt is in the hot seat, especially if you're before the court. The court is not overly forgiving of I didn't know better. They a little bit are to what's called pro se people, which is individuals, but often what happens there is the pro ses make a cavalcade of mistakes that then ends up somebody getting removed because they've just done this really poorly. So anytime you're a fiduciary, keep your records, keep your funds separate, use the money only for the beneficiary. Do not say, hey, I just need this $5,000 for a few months, I'll take a loan and pay it back. I've seen people do that. That's not okay. This is, for the person. And, all of us who kind of, have these children, we're kind of looking that we want them to be taken care of. And to me, touching, a disabled person's money is tantamount to just, you're a terrible human. Okay, next slide. I think we've covered most of the revocable trust stuff. One of the things I just want to bring up is if you do a revocable trust, it operates on your Social Security number. So there's no special tax returns that need to be filed for a revocable living trust. Make sure you've got your assets titled. I'm just reviewing, and make sure if you have non-titled assets, they're under $100,000. So you got the 2 cars and you trade them in, every 10 years, and your cars aren't worth a crazy amount of money. They don't need to be in the trust. If you do have that $200,000 Maserati, put it in the trust. One of the big things that I like to rant on about is trusts really don't save you any taxes. There's a couple ways you can do it. But for the most part, if you die with a will, if you die with a trust, if you die with intestate, your taxes are going to be the same. It just depends upon what you own. Okay, jumping to the next slide. The trusts, I do them often for out-of-state property. I don't think you need to avoid probate if you're living in Washington, but you may absolutely need to do it if you have property in California or New York. Kind of certain states have, the states you would think probably have the worst probate laws. It is a standard practice in a lot of states. When I practice in Ohio, I recommended a lot of revocable trusts. I do a lot less today. One of the things that people kind of don't always understand is if you have a trust, you still need a pour over will, because you miss property out of the trust, you got to get it into the trust. So you still may need to worry about probate. Now let's jump real quickly about taxes. One of the things that people get confused about is there's a lot of different taxes that deal with death. We've talked about estate tax. There's also income tax. And any of you who have looked at your 401ks and they're not a Roth, you're well aware when those get distributed, there's going to be a lot of income tax there. Great way to save for retirement, terrible tax benefit. The other one is capital gains. And capital gains can be an interesting situation. We do now have a Washington capital gain. That is the new law. Capital gains can be short-term or long-term, and it can apply to stock. So you bought Boeing. Well, Boeing's not a good example. You bought Microsoft a long, long time ago for $10, and now it's worth over 100 or 200. You got a lot of capital gain there. But where capital gain becomes a real problem is real estate. And I'm talking a little bit too much about myself, but I used to live in Bellevue, and I could sometimes pick houses of people who were in nursing homes because you could tell it was a house they bought for like $40,000 in 1972. Mom and dad lived there their whole life. One of them passed away. The other one's now in the nursing home. And the kids are trying to do the absolute minimum to keep the house going so that they can inherit it upon death and get a step up in basis. I'm going to use math to try to explain this, but it's going to be very simple math. So you bought the house for $100,000. It's now worth $1 million. If you were to sell that house as an individual, you get $500,000. If you're married, you get $500,000 exemption. If you're single, you get $250,000 exemption. But one of the only benefits of dying is you get a step up in basis. So under today's law, if you bought that house for 100 and you die owning it, you now can sell that house for $1 million and pay no tax. And that is a huge benefit for a lot of people and can be very, very helpful to pass some generational wealth. So be aware of that. Next page, there's never really good news when there's taxes. But as I said, we have a $13 million estate tax exemption today. It's going to change in 2026. One thing that I just want to mention, this only applies when it's passing to people who aren't your spouse. If you leave everything to your spouse, they don't pay any tax. The tax becomes the second person dies is the problem. And if you want to leave everything to charity, is PC2 a 501c3? So if you want to leave everything to PC2, I assume they're a charity. They can you can leave it all to them and they don't pay any tax. The bad news on the next slide is what I talked about before. Washington does have a $2.2 million, and I round up from 2.193 to 22. There is no increase like federal law. There is a small increase for inflation, but we still do have an estate tax in Washington, and that's what most people are doing. Okay, next one. You do your estate plan, you do everything right. When do you need to review? Anytime somebody is born, dies, or comes of age. All big things to do. Asset changes, you inherit, you win the lottery. Let's do that. You don't inherit, you win the lottery. I tell all my clients, when you win the lottery, give me a call and we'll do some different estate planning. And I had a guy do that, and he called me, I won 20 grand. And I'm like, that's not really what I bet. Congratulations. But I was thinking 20 million, not 20 grand. Enjoy your 20 grand. And the big one is major tax law changes, as we're going to have in 2026. So that's the one thing. I'm giving you some future advice. We're going to have some tax law down the road. Now, last thing I will do, and this is the self-serving stuff. I'm not going to push you too hard. Why use an attorney? Well, we get paid the big money because we know this stuff, and qualified estate planning and elder law attorneys know to look at all the different pieces. I have seen people who have done self-help stuff that works just fine. I have seen self-help stuff that blows up. My favorite story, and this will be the last thing I do before I take questions, is I had somebody who, and this is totally dating me. I'm going to say two things that don't exist anymore. One is they went to the Office store. I guess there's still a few of those around, but not as much. They went to Office Max or Office Depot or whatever it was at the time and bought a CD that you put into your computer, because those don't exist anymore, to do their estate planning. And they did a pretty decent job of their trust. Other than they forgot something very important. They never once mentioned a beneficiary. So you had a trust that had everything in it and no beneficiaries. So we ended up in test day having to do what the state says because they didn't name anybody in the trust. And I don't know how they missed it. So what I will say, and this is totally self-serving, it is worth talking to an attorney and getting some advice. Yes, it is expensive, but it is not expensive when you compare it to what potentially the problems could be. And when I'm involved in contested matters, I joke they take like 10 years off my life. I have one of those tomorrow. But people can be irrational and people can fight and people have their own views of what's fair. And that's where we end up with problems. I have a crazy story that I have a hard time believing it was even true, but I met with a couple and they'd done just a basic estate plan, 3 kids, a third, a third, a third, you know, appropriate people as personal representatives. Everything looked good. And then at the end of the meeting, the wife said, I'm going to tell you right now, our daughter's going to contest this. And I'm like, what are you talking about? And they were like, yeah, she thinks she should get it all because she's the daughter. And I'm like, what the heck was that about? And then yeah, she's just spoiled. And I'm like, so I like to tell people anybody can sue anybody for anything. And I cannot keep you from being sued, but I can keep you hopefully from losing. And in that case, you know, that daughter, when that estate goes to probate, that daughter could sue and say, I get 100%. Now, I doubt she's going to find an attorney who's going to represent her. But I'm sometimes surprised at what attorneys will do. And there are a lot of people I don't think know this stuff as well. There are a lot of people who know this very well. There's a lot of people I think who dabble, do other things and play around with this. And I recommend if you are looking for somebody in these situations, somebody who knows disability planning, deals with special needs people, deals with wills, trusts, estates, and guardianships, and they know all this kind of stuff. And we have a lot of good people who do that. So I'm going to end this now and say thank you for listening. And I think we're going to turn this off. Oh, and I'm just going to end before thank you, going back one slide. Don't put it off. Hopefully Nike doesn't sue me. Just do it. That is the most important thing. Get a will. And after just saying attorneys are a good thing, I'd much rather you die with something you got off the internet than nothing. So do it. The powers of attorney, and I should have looked up exactly who they are. I know PC2 can help you with those under certain circumstances, but there are Washington-based powers of attorney on the internet. Washington Law Help, I think, has some. They're better than nothing. Do them. And if you can find a Washington will that says non-intervention, do that as well. So I'm going to say thank you. Please don't put it off. Do not be the ostrich. Do not stick your head in the sand. And can we turn off this recording before I break the internet here?
Well, first of all, I want to take a